to see how, on the basis of that, we would say that there are, Dr. Seska's report maintains that there is ESA on the property other than the Gary Oaks themselves, which are a protected tree.
Through the mayor, the income report on page 97 does say.
I'm sorry.
Sorry, I'm looking at the report at the same time. On page 97.
Yep.
It does state that the greatest botanical value of the property lies within the number of exceptionally large Gary oak trees. That there are native wildflower remnants located closer to Mackenzie Avenue, and there is a remnant plant association in that one area. It does also talk on page 100 that restoration should be considered because of the rarity of the red listed plant community, and in other words, the Gary oak ecosystem. So in the staff report, it does say disappointment. I think that was a word that was used by the Cheskas in this report. But that, in the end, the recommendation was that, and it was followed through, was that the areas with the Gary oak canopy be retained during the development process and bonded for restoration in the future. Does that answer your question?
In part, I follow it. But then I'm still having some difficulty reconciling instructions to the property owners that under exclusion item number 14, if they had a registered professional biologist indicate there was no environmentally sensitive area there, that they could be excluded from the EPA. So it seems inconsistent, and I'm wondering why 2.5 years ago they would have felt that if they got the registered professional biologist's report to say that there's no environmentally sensitive area there, then that there is the potential to restore. I mean, if there's potential to restore, I'm having difficulty understanding the impact of the potential to restore to a previous biodiversity when the system is degraded. And I thought that was the limit of the ask, that the system is degraded to a point where there is no environmentally sensitive area there, versus the opportunity to restore, because you're talking about Seska's report now suggesting there could be a restoration potential there that's significant.
Through the mayor, I believe your question was how do we rationalize the lack of the environmentally significant area with a recommendation to retain and restore an area. And I believe that goes down to the question of defining what an ESA is and the professional opinion of a biologist when you look outside of the strict SCI mapping methodology. So in one report you're seeing one methodology, and in the second report you're seeing a broader methodology.
I have one more question for the Mr. Mayor. Has there ever been then, on record, ground truthing on these properties that there is an ESA in place? On these specific rainbow properties?
No, not to my knowledge.
So there is no reported environmentally sensitive area on these properties that's been ground verified. It's just based on the mapping that there may be.
Yeah, the report by Mr. Lee and by Mr. Sector are the only reports I'm aware of that are specific to these properties.
And they're saying that there isn't one, but that the Gary Oaks would be something we should try to focus on saving.
And the Sector report makes that recommendation.
Thank you.
Councilor German.
Thank you, Mr. Mayor. I was going to move the recommendation, and if there's a seconder, I'll speak to it. The recommendation of staff.
So the recommendation is option 1, that the request to remove the subject properties from the ADPA not be supported. Is that one?
That's the one.
So is there a second for that? Seconded by Councillor
Thank you.
Sanders. Go ahead,
Thank you.
Councillor Brennan.
Thank you very much, Mr. Mayor. This is obviously a very difficult question and one of great concern to the property owners, and I certainly understand that. But there are a number of reasons why I move this recommendation. First of all, there is consideration of the OCP, which I read over carefully again for this meeting. Secondly, the decision we made the last time this application came before us was that we would not remove this property while we were in the process of looking at the EDPA and potentially revising it. We're not finished that. We're still in the process. A third factor in my consideration was that staff has indicated a readiness to expedite the process of examining the mapping for that particular property and making changes that may be needed. That should, I think, address some of the concerns of the property owner. But the most important thing for me is that when I read through the Cheska reports, and indeed the report from JP Sector, what they're really saying is the primary environmental value on these properties is the fact that there are a significant number of large Gary oaks on it that are contiguous with a very large section of Gary oak that runs right through the Christmas Hill area, certainly the adjacent properties, and ultimately rather contiguous to Christmas Hill itself. Those are the most significant values there, and that's what caused the sector report to come to the recommendations already been mentioned. Based on the conclusions of the above analysis, it is recommended that the entirety of the subject property at 4007 Rainbow be removed immediately from the EDPA on the condition, understanding that no subsurface excavation with the potential to harm the roots of the present Gary oaks will occur on this property. Fundamentally, that's saying take it out of the EDPA so long as the same protection as the EDPA offers is continued. Because that's what basically the EDPA in this area is doing right now. We don't have that protection if we just take this property out of the EDPA without some sort of provision. As been mentioned, the tree bylaw does not protect those oaks. It allows any oak that is, and this has got an RS6 designation on it, so it would have considerable subdivision potential. Each lot subdivided would have a footprint for a dwelling on it, and any tree that was within that footprint could be removed. You could also remove trees for servicing corridors. You could also remove trees for establishing driveways. Now, our expectation is we hope that when that process happens, that it would be as judicious as possible, but there is no guarantee in here, there is no protection. I think Mr. Lee indicated that those bylaws protect the trees. I would have to disagree with Mr. Lee in that case. They do not protect those trees. They do not offer the equivalent protection in the EDPA. So at this point, while we're in the middle of the process, I think those trees are important as part of that contiguous area of Gary oak. Not a lot of which remains. It really doesn't. Mr. Lee has a very high standard of what he sees as worthy of protection. And I think he believes fervently in that, and that's fair enough. But it raises the issue of how much is then available to really protect under that standard. I spent a lot of my time this weekend up on Christmas Hill, taking a lot of photographs and brought them back and showed them to my family, and they made the comment to say, gee, it really looks great, and there's the oaks, and there are the camas in bloom right now, but gosh, there's a lot of invasive grasses on Christmas Hill. And there are. Does that mean Christmas Hill is not worthy of protection? We have lost a huge amount in the past of the environmental diversity of this area, and we are continuing to lose that. If we look for intact ecosystems at this point entirely, we will probably protect almost nothing. So we are going to have to look for ecosystems that still provide value of either remaining plants, including Garry Oaks, or that provide a contiguous area of substantial members of those reminiscent ecosystems. I think these properties fit that. And so I will, while the process goes on, I think we need to look at what we need to err on the side of caution, to protecting as much as we can till we get to the EDPA and finally decide what it is that we're going to define. Thank you.
Yeah, before you do that, I'm a little bit confused on some of that. I think I'd like to give Mr. Lee the opportunity to come to the microphone to provide some clarification. Normally I wouldn't do this, but as Councillor Dermott has referenced Mr. Lee many times, and as Mr. Lee has been on the property, I'd like to give him an opportunity to come to the microphone and give us an understanding of why these trees don't attain protection under the tree bylaw and how the EDPA is relative to these trees. That's a question.
So, the trees themselves, and we've seen this in developments around town, is they can be replaced. We don't have the next generation, we don't have the next generation of Garry Oak trees coming up. When you get a development that happens, they have to replant trees on. Dan Dora talked at one of the, I think it was Committee of the Whole, talking about the thousands of trees he's planting. We need the next generation. We need to keep as many trees as we can right now, but we need everybody in Saanich planting more trees. Not just people in the EDPA protecting them. Right now, people are not planting Garry Oak trees because they go, well, grows up, it's in the tree bylaw. I mean, we need people to be encouraged to do these things, not stop them from being on their properties. Can I address another thing?
I'll let you, but I want to ask you a question first. So if these properties were left alone, as is, they weren't subdivided, and these trees were just left alone and protected, what would be their fate?
Eventually they will die, and there will be a huge cover of invasive species underneath, and you will have a whole pile of weed patches all over Saanich that used to be the EDPA, because they have not had anybody else doing any restoration on them. You need to encourage people to do the restoration, not force them to leave a piece of land to go to invasive shrubs and other invasives. There was a piece next door to the Allbird property that was 10-foot high blackberry, broom, ivy.
This is Mercer Lane?
This is Mercer Lane. It just got cleared about 2 months ago. It is back 4-foot high blackberry and all sorts of invasive crucifers and other species, grasses. There is no native plants left on that site. It's a premise that things are going to come back by themselves. These are ecosystems that are in peril, that need help, that need all of our help. It is. You go on Christmas Hill and you see invasive grasses everywhere. Someone needs to start restoring those for the future. This is not about protecting things that are going to get better. They're protecting things that are going to get worse. Weed patches is what you're going to create by this present EDPA. And the last comment I have to make is the EDPA was meant to protect environmentally significant areas. I gave the quote on the EDPA, on the ESA Atlas, that it must follow standards. Why does that document even exist and say those words if that's not going to be followed? You need to be protecting environmentally significant areas. That's what the bylaw is for. The OCP guides that. I don't see that that's what's happening, right?
Thank you. Now, the map that you showed, I'm just going to ask you a couple more questions, then I'll give Councilor German a chance to answer your question. The map that you showed earlier, I think your earlier presentation on these two properties, they were red areas in the region of Saanich, and you described these areas as discontiguous.
Yeah, there's no corridor. Corridors were not mapped in sensitive ecosystem mapping. They were never intended to be mapped at all. Corridors are valuable if you have a park connected by another park and you have the same native vegetation all the way to it. And that's how plants and animals can migrate. If you don't have the same vegetation, gray squirrels are good at going up oak trees and through the corridors, and birds are good at that. But corridors are something very special that need to be carefully thought out.
So how small does an area have to be before it is considered contiguous and is a corridor?
How small?
Yeah. Or how large?
Well, usually when you're talking corridors, you need large, because you need very wide, 100 meters, 200 meters wide, going through swaths of land from one part to another part, or one protected area to another, that have the same vegetation. Otherwise, they're not effective.
Can the corridors exist being broken up by houses? There's a ground component, there's an air component, and you've got houses in the middle of these two discontiguous areas. Is that considered a corridor?
You could have a tree corridor that way, but the understory is critical if you're trying to move native species or invertebrates or small animals, small mammals, or that sort of thing. So, yeah, having houses in between.
Okay, so returning to the example that you gave of Mercer Lane, where the houses were put in place. It's currently the practice that where the trees are removed, Saanich has 2 trees planted in the area. So what is going to be better for that property to have that? I'm just going to suggest this as one of the options. If that property was developed and the trees were planted, could it end up in a healthier state? Especially given the fact that there's no motivation or encouragement or incentive to plant more Gary Oaks on the property in its current state.
I think it's a question for Jeremy Jai, but I think we need trees for the future. We don't need just the trees now. We've got to have both, right? We need the trees now, but we need a whole bunch more younger ones planted. And if, as you say, some come out, you might want to change the tree bylaw for developments, that if one comes out, you plant 10 trees or 5 trees or something that gets more trees planted. And they don't necessarily have to be planted on that site. They could be spread out around the municipality.
Okay, thank you for that. We've only covered tree planting, we haven't covered flourishing understory. I want to give you an opportunity to raise your second point that you were talking about.
Sorry,
You had a second point you wanted to raise.
Oh, it was about the ESA. The other piece, though, was the species at risk that was brought up by James Muskelly. The Cheskos are the provincial experts on sedges. That's a sedge species. They didn't find it on the property next to the rainbow properties. So it's probably not on this property. And to me, that's trying to say, well, it could be another endangered species on there. There could be, but that's not what is mapped on there. Anyways, basically what you have in the EDPA are a whole bunch of mapping errors. When someone did the original sensitive ecosystem mapping and they didn't get a chance to ground check it, you have to look at those boxes. They might be wrong. And the rainbow properties are mapped wrong. And if the original mapper had gone onto those sites, they would have said, this is not a sensitive ecosystem. Take it out.
So what you're saying is it wouldn't have been put in if it had been ground truth.
Exactly.
Now that it's in,
Exactly.
we're having a debate on why it should be removed.
Exactly.
Okay, thank you. I think Councilor German wanted to ask a question.
I'd just like to reply. This is a little bit unusual procedure, so I'd like to, when Mr. Lee is finished, to reply to what he has to say.
All right, thank you, Councilor German. I think with the sensitivity of this issue, and I think it's important to, on some of these issues, to get down to a debate. I'm not trying to move this one direction or another, but I think there's a number of outstanding questions here that need to be asked, because I don't have enough from the report to make a decision. I'm largely relying on what's coming from the audience and what's coming from the council. And to get some higher level debate we normally have here for this kind of issue, I think is worthwhile. But I understand your concern. Councilor Murdoch was next on that list. Thank you, Mr. Lee. You can return your seat.
Thank you. I guess just in the way things have unfolded, I had a question that I was going to ask and didn't have the chance to. And that is, the second part of the recommendation is that if we choose not to remove, that staff would then expedite the review process to make an assessment on the property. And so I just wanted to, I guess, to refine the mapping that applies to the property. So I just wondered if you could tell us what that process would be, so that presumably council will no longer have eyes into what that looks like after it's been in this room. And so what would the property owners expect to see if that was the direction council gave to staff?
If you're speaking to page 8 of the actual council report itself and the recommendation of that motion,
Yes, so the second part of option 1 would be refining the mapping, expediting the process to refine the map.
correct, and in this case, if you supported the request to remove, we would be simply eliminating any EDP on that subject property. That would be the only mapping that we would do.
Sorry, so I guess just, I'm having the same problem Councilor Haynes had in trying to get back to where it was. Okay, so it says, option 1, do not support the request to remove. If council chooses this option, give direction to staff to expedite the process to update the atlas for the properties to increase its accuracy based on the presence of a wilderness polygon. So what I'm asking is, what would the property owner expect the process to be? Because according to our bylaw, from that point on, it's a staff process. Council would not be a part of that.
I'll certainly ask Ms. Pollard to respond to that. Just for clarity, my reference was to page 8 and you're referencing page 7, is that correct?
Okay, yes, thank you.
Through the mayor, the process to update the EDPA atlas, it would come back to council as a mapping improvement. So there would be a map showing where the line is recommended for council to adopt. And then it would also, because it's an OCP document, would require a public hearing, and we needs to finalize that.
Okay, so there would be further process, not dissimilar to this evening's, except that the recommendation would be with respect to refining the EDPA atlas based on that review. Thank you. I appreciate the clarity, and I think it's indicative of the sort of situation we're confronted with this evening. It's the process. What happens when somebody is not pleased with what they find their property, assess finding their properties within this area and what to do about it. I think our CAO made a very good point of clarification earlier when he said 14 and 15 were not about removing properties. They were about making revisions to the map. And I think that the challenge we're finding is that we're now being asked to consider removal irrespective of what the bylaw says, because the bylaw didn't consider it. And so I think I'm finding myself a bit challenged, even though I mean, with the utmost respect for Mr. Lee, for staff, for everybody who has submitted their expertise. It's a bit like, your doctor putting the X-ray up and pointing out different things that are on the X-ray and telling you what that means. You can really only take their word for it. You don't have the background to say yes or no, that appears to be the case. This is going to contribute to that if we don't take these actions. For that reason, I find myself in agreement with Councillor Dermond's comments about the process. Not that, we're in the middle of something and we can't make a decision. I don't think that's quite true. What I think is a likely outcome from the recommendation is a revision to the process to apply, to appeal what's in the EDPA. And I think that what's in there now is imperfect, and we're experiencing exactly that. So the reason I would support the motion on the floor would be to say, in the interim, we need to refine what's in the atlas, because it seems like the first conversation I had with Ms. Bowl is, this line goes right through the middle of the house. And I agree with that, that seems ridiculous. And so refining that makes a lot of sense in the interim. Over the long term, the appeal process needs to be better refined. There needs to be some level of adjudication with informed expertise that allows decision-making to respond to the kinds of requests we have before us this evening. Because I don't think, based on what I'm hearing my colleagues say, and based on my experience reading through these pages of documents, I don't think we're the best body to be doing this kind of adjudication without a more informed basis upon which to make that decision. So I'll be supporting the motion with regret, because I don't think that it deserves to be postponed any further. I do think that it is worthy of having the best possible response we can offer. But I think that the appeal process itself needs to be examined as part of the review as that unfolds.
Thank you, Councillor. I'm a little bit confused by some of this. I just want to get some clarity on it. I think what we heard from the CEO is that if the properties aren't removed from the EPA, the ESAs are removed. But essentially, if there's no ESAs on the property is essentially removed. So I think we're dealing slightly with a technicality. But I'm not clear, and I thank you for your clarification and raising of this item in the option on page 7. But it says here in the report that no new information is provided. It says in the summary, the owner of 4007 and 4011 Rainbow Street have resubmitted their request to be removed from the EPA, and no new information is provided. On the previous page, page 6, under staff comment, it talks about the ENCON environmental report, and I went and took a look at the September 28th agenda, and I see no reference to that report in the original request to remove these two properties, ESAs from these properties, from the EDPA. So this new information has been provided. It's sort of propped in this report. The applicants provided no new information. So my question to staff is, as at this point, if the motion goes forward with the wording in here that says to increase its accuracy, what new information would be coming forward to make this change, to make any change to the ESA?
I believe the original report from last year did have a paragraph on the ENCON report. It may not have been referenced exactly the same way, and it wasn't attached as it was to this report. So information will be looked at in terms of tree information, in terms of critical root zones, and looking at the property, some more look at the soils, to see if there are native soils and what's in the soils in terms of bulbs, etc. Looking to see if this rare sedge is in that location. So a little more field verification, field work, and staff time as well on the property.
Okay, thank you. So who's going to pay for that process?
It would be staff time, so there would be no fee.
Okay, so if that's staff time to do that analysis, and I assume it's going to be done by an RP bio on our staff, why would any EDP owner be required to pay for their own bio just ahead of time if it's just going to come in conflict with the internal opinion? At the end of this process, please, thank you. And if we end up coming back here, or it's left in your department, where we'll be doing it anyway. I don't understand that.
Landowners always have the option of hiring their own professionals. In this particular case, that option was communicated but not recommended because of this very issue that we're facing. So normally staff do provide the service free of charge, landlords request for staff to come out and look at the mapping because they think it may not be quite right. So we provide that service, and we have numerous tweaks to the atlas to bring forward to council as soon as time permits. So it is normally staff, unless there's a development proposal, in which case professional engineers, biologists, landscape architects, etc. are being hired. They become part of the team. So it would be if there's a development proposal.
Okay, thank you for that. I understand that. I think this is showing the difficulty of the process that we're, or the position that we're in right now, is we are going in a few circles. There was a question that, there was a comment that Councilor Murdoch made earlier that I think was very important, was that, and I think I don't want to misquote you, was that council was not the proper place for this. It's better done with staff. But we don't have a structured appeal process. And I believe it's the function of the council to be this level of judicial appeal, if you will. And we don't have that right now. It's something I think we're going to have to get to as we go through the consultant's recommendations and hopefully eventually get there. But there are cases where something has come to council that hasn't had a staff recommendation. And I don't have the time to go through 100 years of Saanich council minutes, but I'm sure there's been a case where something hasn't been recommended, but the council has done something. Probably, it's likely. So I would argue that the council is the body for these kinds of decisions and this kind of appeal. And I think what we have with this particular application is at the appeal stage, where a biologist has been hired, and now we're going to be back to the old Dooley biologist problem, where we have a biologist report from the landowner, we're going to have a biologist report from staff, and who are we going to go with? We have a process in place that says, get a biologist. And many thousands and thousands of dollars have been spent for these biologist reports, which are, in some